The parliamentary impeachment inquiry against suspended Public Protector Advocate Busisiwe Mkhwebane kicks off today. Now, these proceedings serve as a tool to determine whether Mkhwebane is fit to hold office. She's failed in numerous previous court actions to stop the parliamentary process from going ahead. Joining me now is constitutional law expert Advocate Prince Mafu. Advocate Mafu, very good morning to you. Thank you for your time. Welcome to Newzroom Afrika. We know that Advocate Busisiwe Mkhwebane has fought this removal inquiry not only in court but also in correspondence with the National Assembly Speaker, against whom she sought a personal cost order over claimed bias. Now, as this process today gets underway, what can we expect?
Good morning, Paul, and good morning to your viewers. It's a pretty much tough period for the suspended public protector because as things stand right now, at face value, the odds are against her, given that his employers are probing her level of eloquency and adequacy in respect of holding the office of the public protector. So what needs to be expected today is obviously her team will make opening remarks or submissions to the committee about where they stand in respect of this issue, the extent of the fight which they are likely to put, and kind of launch a preemptive defense as to where their position is and what they think about the current process versus the other processes that have since been withdrawn, whether that is still a stance. That's something that the Section 194 committee is still to hear.
And what role will the Section 194 committee be playing in, tabling these discussions and ensuring that there is some sort of fairness for Advocate Mkhwebane as this process kicks off?
Well, one would hope that the MPs duly entrusted in conducting this inquiry will abide by their very own oath of office, to serve, protect, and promote the Constitution without being blindfolded by various political discussions and various political positions where they come from. What the committee is expected is to make a proper finding as to the conduct of the public protector, whether or not she's still worthy and fit and proper to hold the office which she was appointed. Obviously, they will take a combination of factors, her results, which are pretty much obvious, other extenuating circumstances, and every other shred of evidence that's going to be thrown, into the fray by her defense counsel. So we're expecting parliamentarians to deliver as per their own oath of office and not be clouded by their political affiliations and the political positions and the political muddling, which has also tainted this entire process one way or the other, depending on which side of the coin you're coming from.
Yeah, you say the odds are against her. It's been revealed that Mkhwebane spent just over 67,000 rand on fighting legal costs of a parliamentary impeachment inquiry and the presidential suspension over the past 2 years. Now, last week, we heard Acting Public Protector Kollega Galega announcing that the office will not fund Mkhwebane's appeal. There's been some level of criticism against Galega's decision from the likes of, I think, the Jacob Zuma Foundation or the ATM. I can't remember who's who at that point. What's your take on that level of criticism?
Well, what I would probably submit to you is the fact that the fights that Advocate Busisiwe Mkhwebane is fighting in her personal capacity, I don't think the Office of the Public Protector per se is inclined to back her up in respect of that, because you would note that the fights that she's fighting about speak more to herself than her office. So it is pretty much an issue which I've highlighted before, that the issue of the politicizing of the entire process makes it a bit difficult. everyone is kind of jostling for power to show how powerful they are, regardless of the timing, and that is what has clouded this process, and muddying it in the event. So I think, in a nutshell, the acting public protector used her discretion, but she has also vowed to back the suspended public protector in her defense, because what is being probed in Parliament is the office of the public protector and whether or not it has been upheld in a specific manner, which she has said she will back. But personal battles in respect of the suspensions, etc., she has just decided to disassociate herself, which is her discretion. What we can query, though, is probably the timing of it all, given the nature of the relationship between the president and the suspended public protector. Then you add the conduct of the acting public protector. It just fuels a certain notion. But to be precise, I think if the power jostling is the one that is kind of shrouding the entire process and making it very murky.
Yeah, it fuels a certain notion, the debate around the timing of Mkhwebane's suspension. I mean, what does the actual suspension mean when it comes perhaps to the assertion of the importance of the rule of law in South Africa and perhaps some accountability?
Well, that is probably what we would expect the Section 194 committee to even look at, because that kind of conduct already, the public protector we talk about is already suspended. And if I'm counsel for the suspended public protector, I would start there and highlight and have the Section 194 committee, review whether or not the president, when he did what he did, was it bona fide or was it mala fide? What evidence is there? That's something that needs to be probed, because we're looking at the entire spectrum of Advocate Busisiwe Mkhwebane. So I think the suspension as things stand, it's jostled, like I initially indicated, by these power flexing muscles that certain office bearers have, regardless of the timing. I think everyone is just wanting to have a say to fuel this entire situation to whatever end that they think it will benefit them. So that is pretty much problematic, because due process and the bona fide aspect of the entire thing gets compromised in the way. So at the end of the day, it remains clouded whether or not, if the public protector is found to have violated the oath of office, whether what extent political meddling had an impact on that. It becomes very much problematic.
Yeah, and also throughout the many cases, when it comes to perhaps one outstanding matter, there's Mkhwebane's turn to the Concourt to ask it to rescind its decision to dismiss her earlier rescission application. Can this move, you think, be viewed as perhaps undermining the judiciary?
Not at all. Everyone has got a right to exercise, a right of appeal in an instance where they feel the ruling of a lower court has not dealt them a good favor. But howsoever, we need also to see whether there are prospects of success, because that is where it is critically important when the Concourt makes its finding, whether they are going to schedule a hearing or they are simply going to dismiss it, at face value, saying the matter lacks merit. What we have seen over the past is that all her attempts have been pretty much unsuccessful. All her matters have pretty much been thrown away, before court for lack of merit and prospects of success. I don't think this one will bring a unique version of what has been happening. But fact of the matter is, the impact of such a stance could be, to a certain extent, a flexing of one's right, but could also be an abuse of court processes and just time wasting, knowing exactly that there are no merits in the matter. So we await the decision of the Constitutional Court, obviously, for that. But I don't think that embarking on such a process will make any adverse impact in whatever way that she thinks she can claim her rights.
Very well. Thank you so much for your time. Thanks for weighing in. Constitutional law expert, Advocate Prince Mafu.